Alright everyone, in this video we are turning to AP Unit 3. AP Unit 3 focuses on civil liberties, civil rights. This is about 15% of the AP exam. Now, if we do AP Unit 1, AP Unit 2, AP Unit 3, so that's the constitutional foundations, that's the structure of the federal government and the policymaking process, and civil liberties and civil rights, those three units are about 2/3 of the content of what will be on the exam, and it is every Supreme Court case, or just about every Supreme Court case, and all of there's three Supreme Court cases that we're going to talk about in the later units, and every of the required foundational documents are in the content for those three units. So really kind of focusing on units 1 through 3 is going to help you prepare the most efficiently for the exam. So what do we need to know? This is really looking at constitutional protections for rights and liberties. So we're looking at the Bill of Rights, and we're looking at how kind of the fundamental freedoms guaranteed by the Bill of Rights have changed over time. And we're also looking at the role of the Supreme Court in those in changing interpretations of the Bill of Rights, and then we're looking at the questions of equal protection, social movements, civil rights. Right, as you can see from the kind of CED learning kind of CED goals. Right, there's a lot more emphasis on civil liberties and civil rights, but we are still going to be talking about civil rights in the second half of this video. So let's start with kind of figuring out what civil liberties are. So at its most general level, again, civil liberties are ultimately the kind of restraints and restrictions on what the government can do to you. They are protections of certain freedoms or rights or privileges that individuals have. However, civil liberties are always a balancing test, right? We're always trying to balance the needs of individual liberty with the public good, right? So we might be trying to protect freedom of thought and freedom of expression. We might be trying to protect a set of diverse opinions and worldviews and experiences and diverse religious groups and cultures and things like that. But on the other hand, we are trying to maintain safety and security. Right? What if your freedom of assembly starts to impede the safety and security and well-being? We also want to make sure that we're kind of maintaining equal treatment. What if your religious liberty, your free expression of your religious beliefs starts to infringe on the equal protection or equal treatment of minority groups? Finally, we're also thinking about the general welfare of the community or the society. So depending on how we're going to weight these things, these individual liberty or the public good, we can actually see these things shifting from side to side, right? We can actually see kind of a distinction that gets drawn between how we're going to weigh individual liberty versus the public good. Now, usually when we're talking about civil liberties, we're talking about the protections in the Bill of Rights, and that's the first 10 amendments to the Constitution. So this is the Bill of Rights, the amendments 1 through 10, and I've actually kind of color-coded them, right? So the ones that are red, we're talking about limits on government power. The ones that are white, we're talking about privacy and property rights, like your freedom kind of within your own property and your own kind of privacy, right? There's no explicit right to privacy, but we'll talk about that in a bit. And blue are due process rights, right? If you are charged with a crime, what rights do you have if you are accused? Now, some of these blend. For example, the First Amendment, freedom of expression, is both limits on government power. The government cannot compel you to speak or prevent your speak, but that's also kind of a privacy right, right? You have the right to freely worship and exercise your religion as you wish. Similarly, unreasonable search and seizures are both protections in the case that you are accused of a crime, but they also provide a certain implied right over your private property. Now, the other key idea that we need to talk about is the idea of selective incorporation. Now, as the Bill of Rights was originally ratified, these were thought to apply only to congressional actions, right? The Bill of Rights begins with Congress shall make no law, right? The idea that these are limits on what the federal government can do. And there's some kind of historical and legal arguments that the Bill of Rights, as originally conceived, were actually not intended to prohibit these types of laws at the state level. That the states, being more closer to the people, having a closer being more democratically accountable to the people, would have the right to establish a church, for example, or restrict the firearm usage in the context of the needs or of that community and the context of the ability for democratic deliberation within that community. Now, the First, Second, Fourth, Fifth, Sixth, Seventh, and Eighth Amendments have been incorporated to the states. Now, that means that the Supreme Court has held that because of the 14th Amendment that says that no state shall deny the due process rights of individuals in the United States or deny the equal protection of the laws to individuals within the United States, means that the same protections of the Bill of Rights also apply to the states. Now, the idea of selective incorporation is that the 14th Amendment did not automatically apply these to the states, but instead, the 14th Amendment, the courts have used the language of the 14th Amendment to case by case, right by right, clause by clause, incorporate these to the states. The one that is not incorporated is the Third Amendment, which is quartering of soldiers. Right? That is not, there's no case law incorporating that to the states. So we're not going to look at each amendment kind of in detail. It's very easy. You can read the Bill of Rights. It doesn't take that long to go through it. But I want to kind of group together a bunch of different case laws and debates about the different amendments, kind of how the jurisprudence has changed over time. For the First Amendment, right, these fundamental freedom of expressions. The Second Amendment, the right to bear arms. This idea of procedural due process, that's your rights if you are accused of a crime. That's the Fourth, Fifth, Sixth, Seventh, Eighth, and 14th Amendment. And then this broader idea of substantive due process and the links to rights to privacy. So let's look at the First Amendment. The First Amendment we usually think of in terms of the fundamental freedoms. So if we're looking at the freedom of speech, that's like listed first. There's a bunch of shifting kind of precedents here, right? Some of these are required cases like Tinker and Schenck versus the United States, but there is just a broader kind of jurisprudence that your right to freedom of speech is not absolute. For example, in Schenck versus the United States, the court established the clear and present danger test that said that the government can regulate speech that constitutes a clear and present danger to public safety, right? This is the fire in a crowded theater idea. In Chaplinsky versus New Hampshire, the court ruled that fighting words, so words that are viewed as harmful, themselves can be regulated. This has been modified by Brandenburg versus Ohio, in which the court held that speech that directly incites violence or harm is not protected speech, right? That if you are directly inciting violence or directly inciting law breaking, that can be prohibited speech. Now, hate speech, so racist speech, anti-Semitic speech, homophobic speech, generally is protected as free expression unless it violates other kind of tests, other limitations, right? So the idea is that you can say, I hate a minority group or I hate a religious group, but you cannot incite people to violence. And the court has actually held that students get free speech rights in Tinker versus Des Moines, right? That's one of the required cases. The court held that you do not lose your free speech rights at the door when you come to school. Now, if we're looking at freedom of the press, the key case here is New York Times versus the United States, which is this argument about prior restraint, right? Can the government prevent the newspaper from publishing confidential material? And the court basically held that there has a high threshold, that the burden of proof is on the government, that the government cannot simply prohibit the publication of material that would be embarrassing to the government. There has to be an actual very clear public safety and national security concern. Now, if we're looking at kind of religion, remember religion, there's two separate clauses. The first is the Establishment Clause. It says that Congress will not respect the establishment of a religion. This is mostly viewed with this idea of separation of church and state. So the Lemon test, right, this is Lemon versus Kurtzman, says that laws have to have a secular purpose, neutral effects, avoid excessive entanglements. The Lemon test was about public money being used to fund private religious schools. And the court said that, like, look, if we want to avoid Establishment Clause violations, the law has to have a secular purpose, it has to be neutral with respect to different religious groups, and has to avoid excessive entanglements in religion. The court also held in Engel versus Vitale that school prayer, even non-denominational school prayer, school-sponsored prayer, is an Establishment Clause violation. Now, the court has in recent years been walking back Establishment Clause questions. For example, in Kennedy versus Bremerton School District, the court basically said that we've abandoned the Lemon test and that instead, right, we're going to have this like history and traditions framework for evaluating what the Establishment Clause is. And when it ruled that a football coach that leads a prayer at the 50-yard line after a game is not violating the Establishment Clause, and that is free expression of religion protected. The other religious clause is the free exercise clause. And, right, this is where we get the idea that you cannot prohibit someone's free exercise of religion. Now, normally this is fine, but it comes into some certain conflicts, right? For example, there's potential conflict with universalistic laws, right? If we're looking at equal protection laws, public accommodation laws, non-discrimination laws, or, where you get like Masterpiece Cake and 303 Creative cases in Colorado about can a individual for free on religious grounds object to providing services to homosexual couples. In Hobby Lobby versus Burrell, the court ruled that a privately held corporation with deeply held religious convictions against providing hormonal birth control or other forms of contraceptives is not required to, even though the Affordable Care Act says that that health insurance policies provided by employers must cover contraceptives, right? And so you get this kind of like, how much of a religious exemption are you going to get to these like laws that apply universally? There's also the question of religion in schools, right? This is one of the required cases of Wisconsin versus Yoder, of can you compel students to attend schools against their religious beliefs? And the court said there's actually not a compelling reason here to compel school attendance past the 8th grade. Finally, we're looking at petition and assembly, right? And the courts have held that your right to protest, your right to free peaceably assemble is not absolute. That's in Hague versus CAIO, and as upheld what are called time, manner, place restrictions. These are restrictions that would basically provide limits on the types of protest, where you can protest, when you protest, and the manner of protests. All right, you all know and love or hate the Second Amendment. This is the right to bear arms, and a lot of this debate comes down to the language of like a well-regulated militia. So the language in the Second Amendment says that a well-regulated militia being necessary to the defense of a free people, the right to bear arms shall not be infringed, right? And so for a long time, this was not understood to be an individual right to bear arms for any reason, an individual right to own a firearm, but that this was linked to a kind of communal, like in order to maintain citizen militias, we need to maintain these rights. However, in DC versus Heller, the court actually ruled that the Second Amendment actually applies to an individual right to bear arms, that you do not have to be a member of a militia, that you do not have to be have any sort of communal defense force, right? That this is just this individual right. Now, in McDonald versus Chicago, the court then incorporated the logic of Heller that this is an individual right prohibiting states and localities from this is a ruling against the Chicago handgun ban, but saying that states and localities cannot deny this individual right to bear arms, that you cannot have like a handgun ban at the state or local level. So this is a form of selective incorporation, applying the Second Amendment to not just a federal law or a congressional action, but to state and local action. The next set of amendments that we're going to look at is this idea of procedural due process. Now, these are the kind of protections that you have against the government when you are charged with a crime. That in order to punish you for a crime, the government has to follow what's called procedural due process, that you have certain due process rights to before the government can punish you, that you have to basically a fair process of determining your guilt or innocence before you're punished. That the government cannot just like arbitrarily punish you because it thinks you've done a crime. For example, the Fourth Amendment says that you cannot have illegal searches and seizures without probable cause being established, that the government can't just search your house without a warrant, and to get a warrant, they have to establish probable cause. In Mapp versus Ohio, the Supreme Court established the exclusionary rule, which said that any evidence that is obtained in violation of the Fourth Amendment has to be thrown out or excluded from court. That the state cannot use evidence that's illegally obtained against you, right? That the due process isn't just at the trial, it also in terms deals with the investigation. The Fifth Amendment gives you a series of due process rights, right? This is including the right to not incriminate yourself, that you have the right to, that the government cannot just like take your property without due compensation, this idea of like eminent domain. In the Sixth Amendment, you have the right to an attorney in a fair trial. This is incorporated to the states in Gideon versus Wainwright, which says that the states have to have an obligation to provide you with a public defender if you are not able to afford an attorney. In Miranda versus Arizona, the Supreme Court further held that you have to be informed of your due process rights when you are arrested or accused of a crime, including your right to remain silent, your right to an attorney, and that the state is required to provide you with an attorney if you can't afford one, and that the failure to read what have become known as your Miranda rights to you is a violation of your due process rights, and that if a law enforcement officer fails to read you your Miranda rights, that any confession that you give, if you were not aware of your rights, is not binding. The Seventh Amendment says that you have a right to a trial by a jury of your peers, right? That you are not tried just by a magistrate, you're not tried by the state, but that the community, your peers, get to evaluate your guilt or innocence. And the Eighth Amendment prohibits cruel and unusual punishment. Now, that was procedural due process. There's also this idea of substantive due process, which is where we get into this idea of privacy rights. Now, privacy is not explicitly mentioned in the Constitution, but in Griswold versus Connecticut, which struck down an anti-contraceptive law that made it illegal for people to acquire contraceptives, the court argued that there are penumbras and animations from the First, Third, Fourth, Sixth, Ninth, and 14th Amendment that implied a right to privacy. This is then developed into what's called substantive due process, which, because the 14th Amendment says that no person shall be denied their life, liberty, or property without due process of law, which is to say that there are certain substantive rights that are protected by the 14th Amendment that you cannot be denied certain fundamental rights of being a human, right? And these have been this idea that your freedom to live your life as you choose cannot be denied without a due process of law. So this idea of substantive due process has been used to strike down anti-miscegenation laws in Loving versus Virginia. So these are laws that would say that you cannot have mixed interracial marriage. This has been used to protect the right to an abortion in Roe versus Wade, saying that your right to determine whether or not you have a child is a fundamental right about your fundamental lives and liberties that should be protected by the 14th Amendment. It's also been used to strike down, in Lawrence versus Texas, state bans on homosexuality, being your choice on your sexual habits and your sexual partners is a fundamental right flowing from your fundamental rights and liberties, and the state doesn't have any sort of ability to interfere with that. And this idea of substantive due process, as well as equal protection, has been used to uphold marriage equality and strike down state-level laws that would prohibit homosexual couples from being married. In Obergefell versus Hodges, again, these questions are fundamental freedoms, fundamental liberties, that these are part of being a human being, part of being a person. Now, these are very controversial because this is basically implying that there are certain fundamental rights beyond those explicitly listed in the Constitution, and especially justices like Clarence Thomas have been very critical of this idea of substantive due process by saying it's basically allowing judges to invent rights that are not codified in statutes or the Constitution. And we see the rollback against this in the overturning of Roe versus Wade and Dobbs versus Jackson Whole Women's Health, in which they argue that the legal reasoning that Roe versus Wade was based on is fictitious reasoning, and that the substantive due process does not apply here. Now, the actual governing opinion does not apply this logic beyond Roe versus Wade. It doesn't challenge Loving versus Virginia, Lawrence versus Texas, or Obergefell versus Hodges, or Griswold versus Connecticut. But in a concurring opinion, Clarence Thomas does say that because substantive due process is a legal fiction, is not good law, that the Supreme Court should actually review those previous decisions. So that's civil liberties. Now we're going to turn into civil rights, and I'm going to first talk a little bit about kind of civil rights over history, throughout American history, a little bit of historical review, then this idea of equal protection under the law, and the ways of social movements to kind of enact change. All right, so if we are looking, this is kind of a quick review of civil rights in history. If we're looking at the early Republic period after the ratification of the Constitution up until the end of the Civil War, right? If we're looking at equal protection, we really didn't have it, right? Slavery was explicitly protected by the Constitution and legal in many states, right? The Dred Scott decision on the eve of the Civil War upheld that African Americans are not and cannot be citizens because they were not conceived of as citizens during the ratification of the Constitution, and that therefore there are no rights that they have that a white person is bound to protect. Women were disenfranchised, right? throughout the country. There was the rise of the women, or first kind of form of the women's suffrage movement that culminated in the Seneca Falls Conference of 1848. But women were often denied the right to vote. The legal doctrine of curvature basically said that their legal personhood is dissolved into the personhood of their husbands. Native Americans were forcibly removed from their territory. And they were denied citizens. Native Americans were viewed as members of other sovereign nations and were not given any citizenship rights. You get a radical change during the Reconstruction period from 1865 to 1876 when we get the ratification of the 13th, 14th, and 15th Amendments. We've already talked a lot about how the 14th Amendment, this equal protection language, this due process language, not only applies civil liberties to the states, but is used for a more expansive conception of substantive due process, but it also includes this line of equal protection, that no state can deny people the equal protection of the law. We'll talk about that in a second. The 15th Amendment guarantees voting rights regardless of race, but over the course of Reconstruction, these protections get rolled back. During the Gilded Age, throughout till the kind of like the post-war period, right, you have the reinstatement of segregation and the uphold of segregation in Jim Crow against African Americans, upheld by the court in Plessy versus Ferguson, that argued but separate but equal doctrine. You have the emboldening of the women's suffrage movement, culminating in the ratification of women's suffrage. In the 19th Amendment, ratified in 1920. You also, during the kind of late 1800s, you have the loss of Native American sovereignty with a series of wars between the U.S. government and Native nations in the West, culminating in the Dawes Severalty Act, which promised citizenship to Native Americans who severed their ties to their native nations. And you have a series of of kind of immigration restrictions targeted at Asian nations, the Chinese Exclusion Act, you have the Gentleman Agreements with Japan, basically limits on immigration, right? The Chinese Exclusion Act was upheld by the Supreme Court, saying that the federal government can do racial restrictions on immigration. Japanese internment. Japanese Americans were forced to internment camps during World War II out of claims of national security, and the Supreme Court in Korematsu versus United States upheld Japanese internment as constitutional. After the kind of World War II period, we enter kind of like the civil rights movements and their afterlives, right? You get the passage of the civil rights movements kind of beginning in the 50s in earnest, right, with the Montgomery bus boycott, with Brown versus Board of Education, right, culminates in 1964 and 65 with the passage of the Civil Rights Act and the Voting Rights Act. Women's kind of movements expand with the kind of especially focusing on equality with their movement around the Equal Rights Amendment and the question of reproductive equality and reproductive rights with Roe versus Wade before it was then overturned. You have the expansion of the gay rights movement, first in the 60s and 70s, with trying to get people, gay and lesbians and other queer people to come out of the closet and live openly, to the kind of more militant activism in the 80s and 90s around the AIDS crisis, to the fight for marriage equality in the 2000s. The American Indian movement and kind of a revitalization of Native American heritage and Native American culture happens in the 60s and 70s as well. And you have the rise of the Chicano movement, rise of for Hispanic Americans, and kind of continuing debates over immigration that kind of continue today, exactly where the federal government can set the boundaries on immigration, questions of undocumented versus documented immigration, and all those debates are kind of continuing. So the kind of question, the constitutional law question here is this idea of equal protection, right? So generally, in what cases can laws discriminate? And the idea here is that laws should not discriminate on the basis of a protected class without a really good reason, right? So the 9 protected classes are sex, race, age, disability, color, creed, national origin, religion, and genetic information, right? So laws discriminate all the time, right? You might have an age restriction for voting, getting a driver's license, buying tobacco or alcohol, right? You might have different laws about disability, right? But the idea is that you cannot you cannot discriminate without basically a good reason. And those good reasons establish 3 levels of scrutiny. The lowest level of scrutiny, so this would be like age, right, is a rational basis test, right? The discrimination is justified, it's not a constitutional violation if it's rationally related to a legitimate government interest. We have a legitimate government interest in, determining what age you can get a driver's license. Intermediate scrutiny, which is the middle ground here, which is for gender and sex-based discrimination, that you have to have this, the law has to be substantially related to an important government objective, and the burden of proof is on the government to prove that like this discrimination is necessary. So this would be some sort of discrimination, drawing legal distinctions between men and women, or legal distinctions based on like biological sex, right? These distinctions have to be, the government has to prove that there's an important government objective and that the distinctions that they're drawing in the law are substantially related to that governmental objective. Strict scrutiny is reserved for race, ethnicity, religion, national origin. And to have a law that draws distinction on the basis of race or ethnicity or religion is going to be the highest level of standard proof. Burden of proof for the government. The government has to show that there's a compelling state interest with a narrowly tailored law that is the least restrictive means possible, right? That if you're going to have racial or ethnic or religious or national origin-based distinctions in a law, there has to be a very clear reason why that is a compelling state interest, it's a narrow law, that you're trying to do like the least damage possible. Because we can think of kind of scenarios where we might want to draw distinctions on these bases of protected classes, where we do not want to treat all people purely as equal, where we want to be able to draw a distinction between people who maybe can become pregnant and people who cannot, or people who are a different age or not, different levels of ability or things like that. But we need the government, the burden of proof is on the government to justify that. So the last thing I want to talk about are different ways that social movements can kind of achieve change. And this is kind of going back to Unit 2 and thinking about the three branches of government. But a lot of times fights over civil rights and civil liberties begin with social movements and then kind of trying to press the different branches of government, the different levers of power to kind of activate change. So, right, if we're thinking of a social movement, we're often thinking like direct action, nonviolent protest, civil disobedience, right? They're trying to rally and raise the issue salience of an issue, trying to get more people concerned about an issue to affect the policymaking process. They might turn to Congress, right? They might try to get legislation passed. So examples of this would be the passage of the Civil Rights Act, which bars discrimination in employment and public accommodations. The Voting Rights Act, which empowers the Justice Department to make it harder to discriminate on the basis of race for voting laws. Title IX, which requires that all colleges and universities provide an equitable educational environment for men and women. They also could try to get a constitutional amendment passed, right? This is if we're looking at women's suffrage, right? Remember, constitutional amendments often begin in Congress, where they pass both houses of Congress by a 2/3 vote. And now this is harder to achieve, right, especially in highly polarized Congress, to get Congress to actually pass a major civil rights law, but it's going to lead to longer lasting change because you actually have like a law, right, not just like an executive action, not just a court ruling that could get, but a law that is going to empower, it might create an executive agency, and it might empower an executive agency to do something, it might prohibit certain behaviors or actions, right? These types of laws are going to be the biggest forms of change. Now, they can also try to appeal to the president, right? And they can try to get the president to pass an executive order, right? Executive orders, for example, have desegregated the military and desegregated schools. Executive orders under Nixon actually promoted affirmative action. Executive orders around you have executive orders around things like DACA and Don't Ask, Don't Tell, right? That had DACA, which was deferred action for childhood arrivals, that was going to not deport the undocumented immigrants who arrived to the country as children. Don't Ask, Don't Tell under the Clinton administration was going to basically not enforce military bans on homosexuality by basically not asking people their sexuality. There have been, but under the Biden administration, there was an executive order allowing for transgender people to openly serve in the armed forces, and then an executive order in the Trump administration prohibiting that, right? So you can see the president has a lot of discretionary power, especially over the actions of executive agencies to promote civil rights. But these are going to be subject to court challenges, right? Because they still are bound by law. If they're exceeding Congress's statute requirements or unconstitutional, they can get struck down by the court. And they can be easily, as seen in the context of transgender service people, reversed by future presidents. The president, with the stroke of a pen, can just undo a civil rights action that has been taken through an executive order. Now, if we're looking at the courts, right, this is where we often think of civil rights, and that's because we really think about like the idea that the courts are going to overturn an old decision, right? We really think about we're really looking at like Brown versus Board and how it overturned Plessy versus Ferguson, right? But we can also think of this going in the other way, in which Dobbs overturns Roe, right? So the courts can kind of really shift the way that civil rights are interpreted, because they're literally changing the meaning of the Constitution. So this is a pretty big change, but there's some challenges, right? The first is this challenge of enforcement, right? And the aftermath of Brown versus Board of Education, there was massive resistance in which Southern schools districts would close their public schools rather than integrate them. The court had to rule in Brown too that there was, in fact, they were serious and that they actually had to desegregate, and that creates all sorts of problems. Right, so the courts do not have the ability to enforce their law. They're required on the other branches of government and the states to actually enforce their rulings. The other challenge is what the Gerald Rosenberg, a political scientist, calls the hollow hope, which is that the court rulings attract social movements to them, like fly paper to flies, and then the social movements spend a lot of time through litigation because they like see Roe, they see Brown, and they're like, the courts are how we're going to get our rights protected. But the court actions actually lead to more backlash. As we see, the backlash against Roe versus Wade, the backlash against Brown versus Board, and that they would be better off taking congressional action, that you're actually going to get statutory changes to the law, rather than simply a court ruling which is going to generate backlash and be resisted. So this is just to review kind of what you need to know. You should make sure that you're familiar with the Bill of Rights, but especially the fundamental freedoms of the First Amendment, the question of the Second Amendment, the questions of procedural due process, the doctrine of selective incorporation, and this idea of substantive due process and privacy, and then finally, social movements, civil rights, and equal protection. Those are the main things to make sure you're familiar with for Unit 3. Thanks. Next, we'll turn to Units 4 and 5, and we're looking at public opinion and political behavior.